I will talk to you today about ODR for labor disputes. But before that, I will just say a few words about the Cyber Justice Lab, what we do, and what is our main mission and objective. Then we will discuss a little bit labor disputes, and I wanted to present to you today Parlia, which is a platform we built at the Cyber Justice Lab for ODR, and specifically the CNEST project, which I will cover later on, but which is the project of implementation of ODR for the labor board in Quebec, in the province of Quebec, Canada. So don't hesitate to interrupt me if you have any question on any particular slide or subject, although there will be a period for questions at the end. So the Cyber Justice Laboratory is, like Indranil said in his introduction, is an infrastructure research center in collaboration with the University of Montreal and McGill University. Here, actually, you can see in the background, it's a courtroom infrastructure where we test and elaborate technology for the judiciary. So it's kind of a think tank for the modernization of judicial processes. I say here it's a unique infrastructure because there's this digitized courtroom, which is one of the most modern ones that we know of now, and where we can test technology and apply it to real cases or tests or simulations of any kind. So I say at the end here also that we specialize in online dispute resolution. As I mentioned, we're developing technologies, and one of our main focuses is on ODR platforms, and we've developed one which I will cover in a few next slides. But the Cyber Justice Laboratory, it's very important to understand, it's a multidisciplinary facility. It's not only lawyers or IT professionals. So we value very much the multidisciplinary work. We have different researchers from various domains and specializations. You could see here we collaborate with all these disciplines, which are sociology, psychology, anthropology, obvious information technology. As I said, we're developing technology, and obviously law. We're prone a two-phased approach to developing technology for the judiciary, which is the social legal approach, which focuses on studying the legal implications, sociological, psychological, all the social implications of technology in the legal domain, and the techno-legal side of it, if you want, approach. It's all focused on the IT development of this social legal principles, of their application to practical legal cases. So ODR for labor disputes, which is our subject for today, it's well, you probably all know that ODR has for a long time been considered a low intensity, high volume kind of solution for low intensity, high volume disputes. We saw it with Equidir or eBay. That's where it all started. And it has proven to be very efficient and very good. But for labor disputes, we would see new questions arise, which are the varying levels of complexity. I think nobody would disagree to say that labor disputes often come with different levels of complexity, which can be very high, but not always, which can be simply pecuniary and transactional as well. They also come often with emotional charge, which can be higher to a small claims or consumer dispute, where we would contest the functioning of your fridge or any other transaction of low value. And they can also involve a power relationship where if the person is still employed by the employer, and they have an issue which they have to settle using ODR, that can imply new questions and issues that have to be studied. We thought, however, and again, using our approach and studying and involving all the stakeholders in the development of our solution, ODR solution for labor dispute, we gathered all the stakeholders together around the table, the employer representatives, the employee representatives, and everything. I just wanted to mention here, which I didn't yet, it's that our solution and our discussion today is mainly on individual labor disputes. It does not cover collective bargaining, which is a very interesting topic and should obviously like be discussed as well for ODR applications to it, but which raises slightly different um, issues and questions and would be covered by a separate discussion. So yeah, talking about individual labor disputes, we thought of these complexities which you see on the screen, but we also thought that ODR could bring interesting solutions to them. So varying levels of complexity, we have to understand that ODR brings also a possibility to be flexible in the solutions that parties can settle on. Sometimes it's pecuniary, but sometimes it's also asking for excuses or other variations that could be agreeable to both parties. Also important is the synchronous communication option because it has been, I wouldn't say it has been empirically demonstrated because I haven't seen it, but it's pretty common knowledge. I would say that sometimes it's better to sleep over a decision and talk about it with your counsel or even with your family before proceeding, which asynchronous communication allows to do uh, as opposite to in-person mediation, where everything happens a little faster and at the same time. For the emotional charge, we have received feedback from users of our platforms, and not only in labor disputes, but in labor disputes as well, that actually being online and behind your computer helps reducing the level of stress in the mediation process. And the spontaneity also, which is less less important, I would say, in ODR processes, helps reduce the emotional charge and approach the difficulties with a cold mind. And finally, for the power relationship, which can exist between an employee and employer, uh, sometimes not being in the same room while you are in an ODR process helps as well discuss, let's say, helps put aside this emotional charge which we just discussed, and approach and settle an issue more calmly, probably. It also helps if the employee has to stay at the employer. Well, if the employee wants to keep his job, an ODR process may be very useful to settle a pecuniary dispute, let's say, or um, any other dispute, and stay in good terms with its employer. Um, so the Parlia platform is a platform to aid in the resolution of litigation electronically. It is our core platform for ODR, for online dispute resolution. It has been tested before. It has been developed. It has been in development for over close to 10 years now, and it has been tested with different organizations and public bodies in Quebec or in France and in other provinces in Canada. Here we have three examples. So Medisys is a platform we installed and we are using in France for bailiffs. They had legislation a few years ago which rendered mandatory uh, for merchants to offer alternative dispute resolution, and they had already automated processes for dispute resolution. And so they integrated our Parlia platform within a matter of a few weeks, and it has proven very efficient. It covers thousands of cases yearly, and the satisfaction rates are pretty high. The same goes for the Office de la Protection du Consommateur here at the right. This is the Consumer Protection Agency in Quebec, Canada. We have been working with them since 2016 now, if I'm not mistaken. And it has helped them, our ODR Parlia solution has helped them reduce the costs and delays of their disputes by close to 12 times compared to classic court proceedings. And the CAT is the Condominium Authority Tribunal of Ontario, which deals with condominium disputes. Again, it's the same core Parlia platform that has been installed for the CAT, and it has won us awards of innovations, etc., etc. But to come to our Parlia platform, to its application to labor disputes, I'll tell you a few words about the CNEST, which I mentioned in the beginning. The CNEST, it's the Quebec public body regulating employment and labor issues. So they have three divisions: labor standards, pay equity, and occupational health and safety. And we started with them with a pilot project, which is now a pilot project for ODR in their processes. The project is now ongoing. The platform is operational and their users are using it. For now, however, it's focused on labor standards, and it has been narrowed to be eventually scaled. But for now, it's focused on labor standards for obvious reasons that they didn't want to put it out there without knowing what the reaction would be. So a few numbers here about Parlia and the CNEST. For labor standards, which we are concerned with, they had in 2019 close to 43,000 complaints filed. And the 2 points here, why I'm talking about dismissals not made for good and sufficient cause and prohibited practices, is because those are the two sections of the law that Parlia is dealing with at the CNEST right now. So, but it's still a pretty significant chunk of the labor standards field at the CNEST. And unfortunately, I don't have numbers today to show you about the performance of Parlia, because it has been launched in March 2020, and then it was a little bit slow to catch up because of the COVID-19, obviously. But we will very shortly we are right now in an evaluation process to know what the settlement rates are and will be, what are the difficulties, and what the user thinks of it. And it will be published probably on the Cyber Justice Lab website very shortly. So the process of Parlia and for labor disputes is very similar to what we've seen in other areas of disputes of law, such as, like we mentioned, consumer disputes, or condominium disputes, etc. However, while we had our discussions with all the stakeholders, the employers, the employees, it was very important to take into account their challenges and their concerns. And that's what we did. So that's why the first step in Parlia for the CNEST, here it's called filtering. It allows the clerks and the agents of the CNEST to filter the cases that are coming in and apply the predetermined criteria to determine if such case or such a case or other case should proceed in the platform. So, and there's not only the two sections of the law of labor disputes which are evaluated, but also the complexity, the number of years the employee has been employed by its employer. And there are a list of criteria which are evaluated for now, again, because it has been launched not so long ago, and we are still evaluating how it's received. So, but after the filtering process, once your case is selected to proceed through the platform, there's an online help module, which gives you information, which helps you understand the platform, how it works, although it's pretty self-explanatory, and we worked a lot on making it easy to use, user-friendly. But nevertheless, and after you have become more familiar with the platform, the employee can start the negotiation with an offer, and the employer is invited to respond, which brings us to the negotiation phase. And I will show you how it looks in practice. I have a few screenshots of the platform, so we'll go briefly through the process so you'll have a better understanding of what I'm talking to you about. So the negotiation phase, it's pretty classic, although it's a little bit obviously not controlled, but nudged, I would say, towards best to improve the chances of having a settlement in a case. Again, through the process, it has been very important to evaluate the degree of information and nudging that we have to put in to be sure to leave enough freedom and liberty to negotiate and not impact the legal rights of the users. It's also important to understand in the Parlia platform, one of these concerns was that, especially in higher emotionally charged cases, the assistance of a mediator is very much appreciated most of the time. And it has been and it's the case not only in labor law, but in all dispute resolution processes very often. So it is possible from the beginning to request the assistance of the mediator before even coming to the mediation phase. So even in the negotiation phase, you can ask questions if you're not sure about anything to your mediator, who acts in these steps, not as much as a mediator, but as a resource that you can consult to help you in the process. Then at any step also of the negotiation phase, one of the parties can request to go to mediation, which is done online. Again, the mediator is involved. The mediator can help, and you will see how it looks like. The mediation can be done entirely on the platform. Some parties don't like it, so there's also the possibility to launch a web conference or to do it by phone, or even to switch to classic in-person mediation, which is not the point, obviously, with an ODR solution, but it's still possible. And finally, if there's an agreement, hopefully the parties can, not the parties, the mediator, and with the agreement of the parties, can upload the document, the settlement agreement, and it's done then. So I will show you now a few screenshots of how the process goes in the platform. So you have the main steps here at the left: file creation, file completion, etc. I'm sorry, the screenshots are in French. The platform is available in English and Spanish and French, obviously, but I only had access to the French screenshots. But anyways, I will explain it. So here's the first step: file creation. You get a file number, which is secured and personal and secured for your case. You have the information interface here, a few main points that you have to consider and the main steps. Once your file is filed, sorry. So once your case is filed, you get into the validation phase. It's a clerk of the CNEST which goes over it and accepts it to invite the employer afterwards. Once the parties are all connected, the employee and the employer. That's what I was talking to you about. So here you have an exchange of offers and counter offers, but you also have the possibility here in the red button to contact the mediator. Again, we're still in the negotiation phase. The mediator will act as a resource, can answer questions, but the parties can still go on by themselves and negotiate here. Here you have a summary of the case and the different offers that have been made. There are also a lot of filtering criteria with delays to answer, to join a case, etc., which have all been worked out with the personnel of the CNEST. Then you switch to the mediation phase, where you have a forum, a discussion forum. It can be processed in writing, as we see here, but again, you can switch to the phone or to a video conference and go on with the mediation. You have a new button here, which are the documents that have been submitted by the parties. And if we reach an agreement, as I said before, you can find it just here. You can download it, and it's valid and enforceable right away. I would just like to finish by mentioning our works with the autonomy through cyber justice technologies. It brings me back to the lack of statistics today that I wasn't unfortunately able to show you about the platform, but I wanted to mention that we are working in this project, which is a huge project financed by the Canadian Social and Humanities Council. And we are working towards a framework to evaluating the major ODR providers in Canada and their processes. Parlia, OPC is the Consumer Protection Agency I just talked about, CNEST, which we've seen today, and others, the CRT as well. So we're working on this evaluation framework to be able, hopefully, in the near future, give you a better grasp of the results of and impacts of such ODR solutions. So I don't know, that would be my presentation. Do you have any questions, perhaps?
Oh, yes, everyone, please feel free to ask any questions.
Hi. Oh, hi. Have you tried this? Have you tried this at all? It sounds like it's mostly government. Have you tried this in private companies yet?
Just to be sure, you mean Parlia, the platform itself, or applications for labor disputes? But
actually, just both. Both.
Just both. We have, but we are mainly focused on public organizations, courts, and tribunals, and it has been actually one of our at the lab. One of our initial statements or opinion, I would say, it's that ODR, although at the beginnings especially, it was seen more for, like I said, a lower intensity, higher volume dispute, we have always stated that it could be applied and it can be efficient for courts and tribunals, which implies obviously a higher intensity most of the time. So Parlia has been implemented mainly for public organizations. We have not, we have worked with partners in the private sector, but we have not implemented this specific platform in the private sector. And specifically for labor disputes, there are very few, I think, very, very few projects on ODR and labor disputes. And if ever you come across other ODR solutions for labor disputes, we would be glad to discuss about them. But for now, the CRT covers a little bit of labor disputes, but it's definitely, this project is one of the most ambitious ones in the field.
Thank you. I also have a follow-up question. Are you doing this with only unionized employees, or are you doing this with non-union employees?
For now, it's...
does the union have, if it's unionized, does the union have access to the platform, like separate access?
that's the thing. For now, it's not for unionized employees. It's for non-unionized employees at the CNEST. And like I said, we thought about different applications for collective bargaining also, but it raises different questions, and it's a little bit like a different subject for now.
Mark, can you go back?
Oh, please go ahead.
Could you go back to, I think, slide number 1 and number 2? There was a page about partners and the different disciplines.
Yes.
That were involved. There you are. I'm interested. It's a think tank. I'm interested in how change management, what you define as change management, how that figures into cyber justice. Could you speak to that, please?
Change management, actually, of course, it's a very important aspect of any implementation of technology for the judiciary. It implies what we intend by change management is that it implies different processes. Like the judicial field, as you probably know, is very stuck in its traditions, proceedings, and it's very hard to get stakeholders to move, to change their habits. But with technology, to various extents, it's necessary. And to do so in the right way, and to ensure that it does not, again, impact legal rights of anyone, and that we have acceptance, and that stakeholders actually use what technology proposes, change management is central to this. I don't know if it answers.
It definitely answers. I guess it's a continuous process, I imagine.
Absolutely.
It sounds like you're moving bureaucracy. Right now, it's, I guess, how much of this is involved in court systems? Is this all court-based or
well,
no, this is not court-based,
right? I mean, it's not necessarily all court-based. It involves tribunals and public organizations as well. Like the CNEST, it's not a court per se. It has kind of tribunal functions, but it also has complaints and different other fields like occupational safety, health and safety. Like, I mean, it's not necessarily all court and tribunals, but change management is very central to bring in technology to the processes, be it of courts or organizations or even private sector eventually.
So your definition of change management is very integral to IT, information technology, the adaptation of IT to this infrastructure.
And the adaptation of processes to IT, yeah.
Thank you.
Can you speak a bit about the mediators, how they're selected, how they're assigned, what proportion of the cases they're involved in, those kinds of things?
Sure. So we work very closely with the partner for these questions. They already have, before ODR, they already have ADR, alternative dispute resolution. They already have mediators. It's already free. It's already central to their processes. So it's basically the same mediators that have been doing the in-person mediation for the CNEST in that case, but in any other case as well, that brings us again to the change management, who are involved in implementing ODR in their dispute resolution processes. So, and again, that was one of the difficulties actually with the CNES because of the COVID-19. It took us a little bit more time to get mediators on board and get them to use the platform because everybody was overwhelmed with what was happening. But now it turns out that the platform can actually be very helpful in these circumstances because the parties don't have to meet anymore, obviously. So to answer your question, it's the same mediators. They are selected or attributed by collaborating with the partner, and they decide based on their caseload and whatever, they decide which mediators start using the platform. But eventually the objective is obviously to have all the mediators able to resolve cases using the ODR.
Hi, sorry, I have another follow-up question. When you say labor standards, what kind of cases are those? Are those employee discipline cases?
For now, the platform, I'm just going to bring you back to this slide. The platform is focused, so the CNET, they have 3 divisions. And like actual occupational health and safety, it's huge, but it's a little bit different. It's less disputes and it's more regulation of this field. But we are now only in the labor standards and focusing on these 2 issues. So dismissals not made for good and sufficient cause, that's the wording actually of the CNEST. So it's unjustified dismissals basically, and prohibited practices like discrimination, et cetera, so that these are the types of disputes the ODR is used in for now. And I would maybe add, it's specific sections of the law, and there has always been this challenge of simplifying the legal wording for everybody. But and we worked a lot on it here with the CNES, because at some point they wanted the platform to focus on these specific sections of the law with this specific wording. And so the platform has to be very flexible and that's one of the reasons the mediator can be contacted right from the beginning, because some notions may require explanations.
Yes, so do we have more questions? Well, if everyone doesn't mind, I wanted to discuss something with Mark about ODR and labor disputes. And I'd like to hear from you about some of the challenges you face, particularly with labor disputes. As we all know, labor disputes are usually fit in a different category of disputes where there is a lot of tension, there are a lot of emotions between employer-employee, and in normal proceedings, they can be hard to resolve. So if you could tell us more a little bit about the challenges, about how to resolve these problems in an online platform, that would be great.
Sure. So, and you're totally right on point. And that was the question everybody was wondering about when we started this project. And the first step to approach it was, like I mentioned, to bring everyone around the table. And then we started adapting these processes, these online processes, and put it in criteria, filtering of, it's a big and long process of tailoring and configuring the ODR platform to resolve these difficulties that can occur, and especially in labor disputes, which were a pretty new area of application for ODR. So I would say it's work in progress. We get the feedback and we adjust as it is going. But from the beginning, like I said, a lot of these challenges and concerns were dealt with the working group, which involved obviously the agents of the CNEST, but also lawyers, employees representatives, employers representatives, and so it's working out.
That's really great.
Do participants have representation? Do they bring their lawyers to this platform?
They could. It's an option that is configured in the platform. For now, however, they are mainly self-represented litigants, but it's a possibility. Yes, it can be multi-party, and there are accounts that can be opened by representatives like lawyers and counsel.
Yes, and following up on that, I would also like to know if about the mood of all the stakeholders who are involved in the labor dispute process. Are they open to moving things online? Are they really interested in having the best ODR for labor disputes, or do you still see some resistance from the stakeholders who would say that, no, we prefer the in-person method of settling disputes for many reasons?
That's a very interesting point you're bringing in. So obviously, there's always resistance, some kind, somehow. There's always resistance, and we get, like I said, unfortunately, the project is very recent, very young, but we all already start getting feedback from mediators. Some of them say, "Oh, we spend almost the same amount of time, but now we don't mediate. We explain how to access and use the platform." So that's obviously criticism that we're very open to criticism. We are working on resolving. But the interesting thing here is that although there is resistance and some people still only want to consider in-person mediation, the COVID-19 crisis kind of prevented that, kind of put a different perspective on it, because yes, there are pros and cons to being online or in person, but in a context where you cannot be where you cannot meet in person, you either have the option to just not do mediation or try something new.
Yeah, and that's very relevant that especially in COVID times, when you have a platform which serves as an alternative to an in-person process, and with advancements in technology coming in, it's making the whole process more seamless and more user-friendly. So it's great to hear more about it. And I am particularly excited about how things are going for ODR.
Sure. And we are as well. And like I said, we would be glad to discuss and collaborate with everyone who had maybe came across ODR in labor disputes, employment disputes. It's a very interesting field, and there's a lot of work to do.
Yeah, definitely. And I have another follow-up actually. Would you say that your ODR platform, like Parlia, or in general ODR platforms for labor disputes, should they have an element of switching to in-person negotiations or mediation? And if that doesn't work out, switching back to online? Of course, in normal times, not in COVID times where it's mostly going to be online.
Yes, well, actually, it's very interesting because it's something we are discussing with the CNEST, which are a partner and who are using it daily, the platform. And that's one of the options in a few cases where the platform might have been maybe not very adapted to one kind of dispute specifically, where parties wanted, and the possibility is there, parties can, with the assistance of the mediator, switch to classic mediation process. But what is very interesting is that sometimes when the mediation fails, they have a recall of mediation. After some time passes, mediation has failed for any reason. And before going to the next step, they have sometimes a recall saying, do you want to try mediation again and settle the few issues that were left? And in that case, it has been discussed and considered that going in the platform after already meeting in person and trying to settle, going and trying to settle online, putting aside these cons, I would say, of meeting in person, of being in the same room, of maybe not liking each other, et cetera, going on the platform afterwards might be a solution to resolve this mediation that has failed in the first place.
Yeah, that's really good. That's really interesting. And it's good to enable people to have alternative options within the online process as well, because the ultimate goal is to resolve the dispute. And that's definitely something that will help. And we have a question from Vin in the chat. He's saying, can you talk about whether there is a preference for settlements or agreements, and how important is settlement versus a satisfaction with procedural or process justice?
I would, Vin, if possible, I would like to just clarify the question. When you say how important, I mean, could you please just clarify this point for me?
Sure, I'd be happy to, Mark. You know, when I mediate in workplaces, there's either a transformative, there's a couple of justice approaches that I use, whether it be, you know, distributive justice or process justice or interactional justice, right? And so it doesn't, the organization that mediate with don't necessarily say we have to come to settlement. These are in person so far, and some of it is online courts, but there isn't necessarily a need for settlement. There is a hope that people will come back and use the process again, because sometimes people experience satisfaction or transformation in these processes. And so the ADR organizations don't require us to move to settlement, but to attend to, you know, process justice, interactional justice. And so in this platform, is there a leaning towards settlement, which is more about distributive justice, or is there, you know, allowances for other types of satisfaction or other types of justices?
Thank you very much for this question, because we could have a very long and interesting discussion on this. To answer your question specifically, in the platform, mediators have been involved in the whole process of putting it in place. And obviously, they insisted on keeping this flexibility and the different options, all different options open. And one of the things perhaps I would mention as well is that it is very important that the parties get some kind of satisfaction, or we also call it sense of justice, going through the process, even if they haven't settled. And again, we don't have the numbers for Parlia for the CNEST as of yet, but one of our projects with the Consumer Protection Agency, the satisfaction rate of users is much higher percentage-wise than the settlement rate. That means, and I don't want to give the I think it's like 70% settlement rate and close to 90% satisfaction rate. That means that even the parties that haven't settled, that it didn't work for them, they were satisfied with how the process went on.
So you're taking into account both types of satisfaction, so to speak, people's willingness to, people's satisfaction with the process and people's outcome.
Yep.
Okay.
Yeah, definitely. And like I mentioned, we have a working group in this big research project, which is ACT, Autonomy Through Cyber Justice, which is now working on an evaluation framework to evaluate all the pertinent implications and aspects of the process.
Thank you, Mark.
Yes, thank you so much. And
if I may, kindly.
Oh, yes,
my
sure.
name is yes, thank you. My name is Wangari and I'm from Kenya, and thank you very much for the presentation. My inquiry is whether the platform you've designed is expected to be a universal, that it can actually be able to be applicable in any country, or based on the specifications you've worked on, it's very specific to serve the target client and also the region that you're in. And then also, secondly, I also find it quite interesting that you are within the university system, because I think academia collaboration with us as professional mediators and also people who are developing platforms in ODR, I think there's a great opportunity and synergy in that area. Thank you very much.
Thank you very much, because this questions, well, there are two parts to the question. I would first of all say that yes, we are a university, and this Cyber Justice Laboratory is a very large collaboration between professionals and professors around the world. As for your first question concerning the ODR, the platform and its applications, it's important. It's not a one-size-fits-all approach. But the customization is based on configuration. So like I said, Parlia, the platform itself, it's a core of different modules that can be very easily applied to different areas of disputes, jurisdictions. Like I said, we are working in France, in different jurisdictions in Canada. So it can be applied to in different countries and different contexts. But the second step of putting in place a solution like this, like I said, it's bringing everyone around the table. In every jurisdiction, you will have to do it, because if you just plug in a platform and try to use it, most of the time it will probably fail because it's not adapted to the stakeholders. So the platform is very flexible, adaptable, but you have to do it so that your stakeholders accept it, use it, and that you reduce to the maximum the resistance, to the use of the platform.
What sort of outreach or has there been to the private sector, or what's the private sector's participation beyond the partner level in terms of usage so far?
For the Parlia platform, we are working on very advanced possibilities to use the technology, and private sector partners are very interested in, for example, AI applications to dispute resolution or to their processes. So different partners are involved to different extent. But the private sector, they try our research, they participate in our research. So yeah, mainly.
Yes, thank you, Mark. Do we have more questions coming in?
I guess I'm trying to think as I fashion this question, is the main goal of this platform is to reduce litigation, or might it be to just offer an alternative way of settling disputes? Those are two separate questions.
And I would answer it in a third way. I would say the main objective is this all-encompassing goal of improving access to justice. So our goal is to make it easier for the parties to have their issues and disputes resolved. If it implies more litigation or less litigation, it's it's up to them, I would say, as long as it improves access to justice for everyone.
Thank you.
Yes, definitely. I agree with Mark when he says that the really important goal for an ODR platform is to give people access to justice. And one of the biggest criticisms of all traditional legal systems has been that uh, everyone does not simply have access to the courts. People do not have access to good litigation services to represent their cases. And this is where ODR comes in. And if it is providing people, whether it is an alternate forum or whether it is the first forum before litigation, it definitely gives everybody a chance to air out their grievances, to pursue their complaints, and have a process which will enable them to have their rights vindicated. And that's where the access to justice is such an important feature of any ODR platform. And I am, as I said before, I am excited to see that we have ODR coming in labor disputes, and it's definitely going to benefit all the stakeholders, from the employers to the employees and everyone else. So thank you very much, Mark, for telling us more about this. And yeah, we still have some more time. So if anybody has any questions, please feel free to just unmute yourself and ask. And if not, then Mark, do you have any concluding remarks, thoughts about challenges for the future and where you'd like to see us going in this direction?
I would just say, well, first of all, yes, thank you everyone for your presence and for your very interesting questions. I would say that what it shows, this whole project and work going around ODR, and specifically ODR for labor disputes, it's a proven fact that ODR can be applied in various types and areas of disputes. The bigger questions, and most importantly, it's how we do it, and the best way to do it, and the best way to adapt it to the needs and concerns of the citizens and end users. So I would conclude on that. It was very interesting talking to you today. Thank you very much.
Yes, it was great to hear from you, Mark, and a round of applause to you for telling us more about ODR for labor disputes. And I'm sure everyone can feel free to reach out to Mark if they have any follow-up questions. The links are there in the Cyberweek agenda. And Mark, please feel free to reach out to everyone as well. And it was great to hear from everyone. Thank you, Mark, again for the presentation. Thank you, everyone, for the questions. And we can conclude our session today.
Thank you.
Have a good
Absolutely.
day.
You too. Bye, everyone.
Hi, Barbara and Wangari. I'll be ending the meeting, so please don't feel offended if the meeting room ends. Do you have any questions or any follow-up before I close the meeting?
No, it's an area I know nothing about. So really, it's just trying to educate myself, you know. I mean, it's such a wide diversity of platforms and things. It's quite mind-blowing, actually. Yeah, so.
Oh, yeah, absolutely. I mean, initially, I think ODR was limited, as Mark said, to only a certain kind of disputes, usually just minor consumer complaints or something like that. But now it's sort of growing and expanding to every area. So every day we learn a little bit more.
Yeah, the first time I saw was in Australia 10 years ago. And that was family work with people in the outback, where it was just thousands of miles for them to travel. And that was a split screen sort of model. I think it was Skype.
It might have been Skype.
Yeah, an old version of Skype. But I mean, that was the first time, because I hadn't seen anything like that at all. And I think Colin Rule was at that conference, because it was all very new to me. I didn't even know who he was then. So, yeah, very interesting to see.
Oh, absolutely. Yeah. I mean, Colin couldn't be here today, else he would have been happy to tell us more about that experience.
Yes. But, yeah. Well, it wasn't about online. It was actually quite an ordinary type of conference, but there were conference streams and workshops, and that was one of them, which I remember very well. But he wasn't presenting it. It was a team of Australians presenting it. But we've gone so far from there now with all this sophisticated platform and everything. Yeah. Yes. So yeah, I mean, it's just trying to keep on top of it all.
Oh, yeah, it is a little bit challenging, because the technology is evolving so fast, and so many stakeholders are so quick to adopt the technology that it's hard to keep track of how things are changing, and they're changing every day.
Yeah.
But that's the pace of the world now. It's fast.
Yes. Yes. I'm not so much talking about dispute resolution, but certainly not everybody's very keen on Zoom. It's still not got a great reputation. I know I have a Swiss friend who's not allowed to use it for her work. She has to use WebEx. And I don't quite know why that is, except that the Swiss data protection rules are much stricter certainly than the European ones even.
Oh, yeah. That's interesting.
Yeah, they really are very, very tight. And you know, they have their own servers and things, you know, it's very, very different.
Yeah. That's really interesting. That would mean all the data has to be internal within Switzerland. It cannot really go out.
Yeah.
So yeah, that would.
There is a platform, a search engine. I mean, I know there are many, many of those now, but there is one put together in Switzerland called Swiss Cows, and that is basically it's not, again, it's not for dispute resolution, but it's quite a moral platform that doesn't allow, for example, it doesn't have anything to do with unsavory things that you wouldn't want a child to see. So it's recommended for children, you know. I'm awfully sorry, I'm going to have to take this call.
Yeah, absolutely.
Lovely to catch up with you.
Yep, definitely.
Thank you. Please, thank
you.
you.
Bye-bye, take care.
Bye-bye. Bye-bye.